Hi, I'm Anna Denton-Jones, and basically I've got fed up of writing things about coronavirus and have decided to switch to answering various questions, themes that keep emerging in this format instead. I was supposed to have my hair cut yesterday, so over the coming weeks you will find my hair probably getting madder and madder and bushier. So apologies if I start to look more and more scruffy. So obviously lots and lots of questions about coronavirus, and I think I have now published 3 different sets of frequently asked questions documents. You'll find them on the website for Refreshing Law, www.refreshinglaw.co.uk. In addition to those things, I'm going to tackle a number of different themes. So the first thing I wanted to tackle was something that has been announced this afternoon. So that is Friday the 27th of March. And this is in relation to employers where you have got people who are in work and your holiday year may be coming to an end now, and you may be struggling to allow people to take the annual leave that they have due to them because you're either short-staffed because people are taking some time off sick, or because you're just so busy that you can't accommodate them taking that holiday. Some amendment regulations have been announced today that allow workers to carry forward holiday. So this is a one-off special related to coronavirus issue. They can carry forward the 4 weeks of their annual leave under the working time regulations, not the full 5.6 weeks. If you remember, in the UK, we've got that slightly odd 1.6 weeks that relates to bank holidays that was negotiated later. This only applies to the first 4 weeks, but they can carry those forward for up to a 2-year period now. So hopefully that gives you some time to even out the dealing with of holidays over that period and relieve the pressure that you might otherwise be under. So that's the first issue. The second issue I was going to pick up on was in relation to a sick pay question. Many of you will know that the SSP regulations dealing with sick pay had, again, coronavirus-related amendment regulations that are backdated to the 13th of March. And those regulations changed the definition of incapacity for the purposes of SSP. So it's no longer just people who are actually sick. Those people who have been told to isolate themselves to prevent infection or contamination in relation to coronavirus, in accordance with the guidance that's being issued by Public Health England, those people are protected as incapacitated for the purposes of SSP. There are some gaps in that legislation though. So some people are being encouraged to socially distance, which is a separate thing. So that guidance that relates to the over 70s, people with underlying health conditions like diabetes, people who are overweight, pregnant, etc., they are being encouraged to socially distance and instead work from home wherever that's possible, make adjustments to travel arrangements, for example. But those people aren't being told to isolate unless, of course, they've got symptoms or they live with somebody who has got symptoms, in which case you fall into the incapacitated category. So there are those people who actually are not triggering SSP yet. Lots of employers, I think, are going above and beyond and are treating it as if. So bear that in mind. The other issue, of course, is somebody might well be sick for the purposes of SSP, but what does that mean for the purposes of company sick pay or contractual sick pay that goes above and beyond that basic floor of SSP? And the two don't necessarily go hand in hand. So people who are being advised to stay at home because of coronavirus may well qualify for SSP because of the change in the regulations, but they aren't actually sick. And your contractual sick pay scheme, I suspect if you have a look at it, refers to if you are incapable of working due to ill health, or if you are sick, you get this. So there is an argument potentially there for employers around that issue. Another question that I was going to deal with relates to pregnant women and our duty to them. Obviously, you will all understand that you've got a special duty to risk assess in relation to those pregnant women, and where risks are identified, take reasonable measures to remove those risks. And certainly the guidance will be about working 2 meters distance from anybody else, working from home wherever that's possible, changing travel arrangements if possible. But it may well be that you decide that that person cannot safely work. And at that point, if that is identified, you have a duty then to suspend them on full pay for as long as is necessary to avoid the risks that you've identified. Of course, if you have suspended them on full pay for those reasons, then at the point that is 6 weeks before the expected week of confinement, if they are medically suspended for that reason, then ordinary maternity leave can be triggered early in those cases, so you have to watch out for that one. What about the employee who doesn't want to come in? So let's assume they're not on the list of people who've been told to self-isolate or to shield. They're not actually sick. You haven't actually closed down in your entirety, you haven't furloughed them, and they're not actually at risk of redundancy because you've got no diminution in your requirements for that person, but they are saying they don't want to come in. Could that be a conduct issue? Well, yes, potentially it could. I think at most you're probably in final written warning territory rather than a dismissal. And if you were minded to dismiss, I think you'd have to be very, very careful. And the reason for that is Section 100 of the Employment Rights Act, which is one you might have forgotten about. Section 100 allows an employee, it's the health and safety part of the legislation, and it allows an employee who believes that there are circumstances in work that are dangerous, serious, and that are imminent to leave that workplace because of that threat, and a dismissal in those circumstances is an automatically unfair dismissal, so go directly to jail, do not pass go, kind of thing. There is a case called Harvest Press and McCafferty that's a bullying related case where somebody felt threatened by the treatment they were receiving in the workplace. So it's clear from that it's not a requirement for it to be an organisational health and safety risk, if you like, to cause the concern. So I think coronavirus would be deemed by a tribunal to come into that category. Another issue that I wanted to pick up on is where somebody has come into work and you think they have got symptoms. I think the chances of this happening now are slimmer. Could you discipline somebody if you found out that despite your instructing employees not to come in if they're coughing, for example, or they've got a temperature or whatever the instructions are to them, is it a disciplinary issue if they then breach that rule? Well, yes, of course, potentially it is. I think, like always, when we're talking about disciplinary issues, we're going to have to show that you have set out to them that there are these requirements in order for you to then be justified taking some kind of disciplinary action. If it's been a bit more woolly and you haven't been clear and you haven't been telling people, then the chances of it being reasonable for you to take disciplinary action obviously will be much slimmer. And likewise, if the circumstances of somebody being in work with symptoms is such that they couldn't reasonably be expected, I guess, to know that there's a problem, then again, it would be unfair to take any action. So where somebody has become ill themselves through contact with others, where they've just got no idea that that's happened, that isn't going to be a reasonable thing for an employee to do. The other question that I've been asked quite a lot this week is whether or not somebody, if they become infected, they think through work, can they bring some kind of legal action against the employer? Employers are undoubtedly aware of their duty of care towards people, and they worry about liability if people do suffer a personal injury in the workplace. I think the chances of a successful claim here are really slim. The big difficulty for anybody trying to bring such an argument is, of course, how would you prove causation? How would you know where they caught it from, etc. So I think as long as you are doing all the sensible things and you're following the guidance, you're unlikely to be found to be negligent in the way that you're treating your staff. If you have got any further questions, then A. Denton at Refreshing Law Limited, LTD, the shortened form of limited.co.uk. That's all one word. A. Denton at refreshinglawltd.co.uk. You're more than welcome to send those questions through. Hopefully we will revert to a fairly normal service about other topics soon, but until then, stay safe everybody, and I look forward to hearing from you.